Did you know that thousands of people in California could suddenly face deportation as early as February 2026? That's right. New rules are being introduced that could change the lives of many residents overnight, and some of these changes are shocking, even for those who have lived in the U.S. for years. Imagine getting a notice that you must leave the country, not because of a new crime, but because of a rule you didn't even know existed. It sounds dramatic, but it's very real. What makes this even more alarming is that the rules are stricter than ever, targeting people who might have thought they were safe. From minor visa overstays to pending legal cases, almost anyone could suddenly find themselves on the radar. Even residents in sanctuary cities like parts of California are not completely immune. In this video, we're going to break down exactly who could be affected, why, and what steps you might take to protect yourself or your loved ones. By the end, you'll see just how serious these new rules are and why being informed could make all the difference. Number 1. Prior criminal convictions. One of the most common and yet most overlooked reasons people face deportation in California is having a prior criminal conviction. Even if it happened years ago or you thought it was minor, certain offenses can suddenly put you on the radar. From petty theft to DUIs or even more serious charges, federal immigration authorities are increasingly focusing on individuals with any criminal history. The law doesn't just look at the severity of the crime, it also considers the potential risk you are deemed to pose to the community. Studies show that people with criminal records are often prioritized for removal, especially if their convictions involve multiple charges or repeated offenses. What's shocking is that even offenses that seemed insignificant at the time can now have serious consequences under the new 2026 rules. Many residents may not realize that old cases can resurface during routine immigration checks, and failure to disclose them or even forgetting them can trigger immediate action. So what can you do if you or someone you know falls into this category? The first step is to be proactive. Gather all legal records, understand exactly what your conviction entails, and consult with an immigration attorney as soon as possible. Ignorance is not a defense, but knowledge and preparation can make a huge difference. Being aware, transparent, and legally prepared could be the key factor that determines whether you stay or face deportation. We've put hours of research into making this video just for you, so if it helped you even a little, subscribe. It's just one click and it supports all our hard work. Drop a comment below sharing your thoughts or experiences. We want to hear your story. Number 2. Visa overstays. One of the most surprising reasons people face deportation under the new February 2026 rules is staying in the U.S. beyond your visa's expiration date. You might think that a few extra months wouldn't matter, but immigration authorities are now taking visa overstays more seriously than ever. Even if you have lived and worked in California for years, a simple lapse in your visa status could suddenly put you at risk. The law is strict, and enforcement is ramping up. Recent government updates show that ICE and other federal agencies are focusing heavily on individuals who have overstayed their visas. They're using advanced tracking systems to detect expired visas and prioritize these cases for deportation. The shocking part? Many people don't even realize their visa has lapsed until they receive a notice, or worse, until they are picked up for deportation. Minor oversights, like missing a renewal date or failing to update your address, can trigger serious consequences. So what can you do to protect yourself? Start by checking the expiration date on every visa or permit you hold. If it's nearing its end, apply for an extension immediately. Keep all documentation up to date and make sure your address and personal information are current with USCIS. Consulting an immigration attorney can also help you navigate complex rules and explore any available relief options. Remember, being proactive can be the difference between staying in California and facing sudden deportation. We've worked tirelessly to bring you these life-changing insights, so if it helped even a little, subscribe. It's just one click, and it fuels all our hard work. Share your thoughts or personal experiences in the comments. We read every single one, and your story matters. Number 3. Undocumented workers in certain sectors. Another group at high risk under the new February 2026 rules is undocumented workers in specific industries, particularly in sectors like agriculture, construction, and hospitality. These are fields where California has a large workforce relying heavily on immigrant labor. While many people have worked here for years without issue, the new regulations are cracking down on employers and employees alike, making undocumented workers especially vulnerable. Even long-term employment won't necessarily protect someone if their status is not legal. Recent reports show that federal agencies are increasing inspections in monitoring workplaces where undocumented workers are common. The aim is to identify and prioritize individuals who are in the country without proper authorization. Shockingly, this enforcement can happen even in workplaces where employers have historically turned a blind eye, meaning employees could suddenly face notices to appear for deportation. Many people are unaware that simply showing up to work could make them a target under these new policies. So, what can you do if you or someone you know might be affected? First, confirm your employment records and legal status. Understand your rights as a worker and be aware of any documents you may need to provide. If you're uncertain, consulting with an immigration lawyer or advocacy organization can make a significant difference. Being proactive, informed, and prepared can help you avoid sudden surprises and reduce the risk of facing deportation. Knowledge and action are your best defenses. We've put countless hours into researching these crucial updates, so if this video helped even a little, subscribe. It's just one click and supports all our hard work. Drop a comment below sharing your experiences or thoughts. We truly want to hear from you. Number 4. Individuals who avoid check-ins. Another critical group facing deportation under the new February 2026 rules are people who fail to show up for mandatory immigration check-ins. These check-ins are required for certain visa holders, asylum seekers, or individuals with pending legal cases. While some might think missing an appointment is harmless, immigration authorities now view it as a serious red flag, signaling non-compliance. Even skipping a single check-in could put someone directly in the crosshairs of deportation enforcement. Federal agencies have intensified their monitoring systems, flagging anyone who misses appointments or fails to respond to notices. The consequences are swift. Failure to comply can lead to expedited removal procedures, leaving individuals little time to prepare or appeal. Shockingly, many people are unaware that missed check-ins can override other factors, like years of legal residence or community ties. Simply neglecting an appointment could result in a sudden notice requiring you to leave the country. So how can you protect yourself? The key is simple but critical. Always attend your check-ins, keep documentation of your appointments, and communicate proactively if something prevents you from attending. If there's any confusion, consult an immigration attorney immediately. By taking these steps, you're not just following the rules, you're safeguarding your future in California. Being responsible, organized, and proactive can literally save your residency. We've poured hours of research into this video, so if it gave you valuable insights, subscribe. It's just one click and it supports all our hard work. Share your thoughts or experiences in the comments below. We want to hear your story, and it could help someone else too.
Number 5. Recent policy changes targeting sanctuary cities. Many people in California have long believed that living in a sanctuary city protects them from federal immigration enforcement. Cities like San Francisco, Los Angeles, and Oakland have policies limiting local cooperation with federal authorities, giving residents a sense of safety. But the new February 2026 rules are changing the game. Federal authorities are now implementing measures that can target residents even in these so-called safe zones. This means that even if your city has protections, certain federal priorities can override local policies. Recent updates indicate that ICE and other federal agencies will increase information sharing and enforcement in sanctuary areas, focusing on individuals who fall into priority categories, like criminal records, visa overstays, or missed check-ins. Shockingly, this could include people who previously felt completely shielded by city policies. For many, this is a wake-up call. Living in a sanctuary city no longer guarantees immunity from deportation. Even long-term residents could suddenly find themselves receiving notices or being monitored more closely. So what can you do if you live in a sanctuary city and are concerned? Stay informed about federal policy updates, know your rights, and keep all your legal documentation in order. Consulting an immigration attorney can help you navigate these changes and prepare for any unexpected developments. Remember, knowledge is power, and in this case, being informed could be the difference between staying in California and facing sudden deportation. We've put countless hours into researching these important updates, so if this video gave you insight, subscribe. It's just one click and helps us keep bringing you this crucial information. Comment below with your thoughts or experiences. We genuinely want to hear from you, and your story could help others stay informed.
Number 6. Individuals with outstanding deportation orders. One of the most urgent groups at risk under the February 2026 rules are people who already have outstanding deportation orders. These are individuals who at some point were ordered to leave the U.S., but either didn't comply, appealed unsuccessfully, or never fully resolved their case. Even if you've been living quietly in California for years, having an unresolved deportation order now puts you at the top of federal enforcement priorities. Federal agencies are intensifying efforts to clear backlogs and enforce pending cases, meaning people with outstanding orders could suddenly receive notices to appear or even face immediate removal. What's particularly shocking is that authorities are combining old records with new enforcement tools, making it easier than ever to locate and act on these cases. Many residents assume that time or inaction has protected them, but under the new 2026 rules, old orders can resurface at any moment. So what steps can someone take if they fall into this category? The most important action is to consult an experienced immigration attorney immediately. Understanding the specifics of your case, exploring any remaining appeals, and gathering documentation can make a critical difference. Ignoring an outstanding order is no longer an option. Being proactive is your best defense against sudden deportation. Staying informed, legally prepared, and aware of deadlines could literally determine whether you remain in California or face removal. We've poured hours into uncovering these crucial updates, so if this video gave you even a small advantage, subscribe. It's just one click and fuels all our hard work. Share your experiences or questions in the comments below. Your story could help someone else navigate these challenging rules. Number 7. Fraudulent documentation. Another major reason people could face deportation under the February 2026 rules is using fraudulent or altered documents. This includes fake Social Security cards, fake visas, forged work permits, or even minor errors on official paperwork that were never corrected. Many people assume that small mistakes or outdated documents won't matter, but under the new rules, any hint of fraud or misrepresentation can make someone an immediate target for deportation. Federal authorities are now placing a heavier emphasis on verifying documentation, cross-referencing records, and targeting individuals whose papers appear suspicious. Shockingly, even long-term residents who've worked, rented, or studied in California could face scrutiny if their documents raise red flags. Cases that might have been overlooked in the past are now actively investigated, making it crucial to stay vigilant. So, what can you do if your documents aren't fully up to date or you fear an error? The first step is to gather all your official records and review them carefully. Correct any inaccuracies, ensure your work permits and visas are valid, and consult an immigration attorney if you're unsure about anything. Being proactive and transparent can prevent a minor mistake from escalating into a deportation case. Remember, the law is unforgiving when it comes to paperwork, but knowledge and preparation are your best defenses. We've spent countless hours researching these crucial updates, so if this video gave you valuable insights, subscribe. It's just one click and helps support all our hard work. Drop a comment below sharing your experiences or questions. Your input could help someone else stay informed and protected. Number 8. Individuals who recently crossed borders without legal entry.
One of the most vulnerable groups under the February 2026 rules are people who have recently entered the U.S. without legal authorization. While many might assume that crossing the border unnoticed means starting fresh is possible, federal authorities are now using advanced monitoring systems to detect new entries and prioritize deportation cases. Even those who have been careful or stayed under the radar for a short time are at significant risk. Recent immigration reports indicate that authorities are focusing on recent arrivals as part of a push to enforce stricter rules in 2026. The goal is to prevent illegal entry from becoming a long-term situation, but the reality is that this also means people who may have just crossed without proper documentation are immediately flagged. Shockingly, some individuals are being tracked and issued notices almost as soon as they are identified, leaving very little time to take action. So, what can you do if you or someone you know recently crossed without legal entry? The key is to seek legal guidance immediately. An experienced immigration attorney can help explore potential relief options, such as asylum claims or other forms of legal entry, if eligible. It's also essential to stay informed about current laws and avoid situations that could draw attention from federal authorities. Being proactive, informed, and legally prepared can make all the difference between remaining in the U.S. legally and facing sudden deportation. We've invested hours into researching these critical updates, so if this video helped you understand the risks, subscribe. It's just one click and supports all the effort we put into these videos. Share your thoughts or experiences in the comments below. Your story could guide and protect someone else.
Number 9. Certain asylum seekers with pending or denied cases. Asylum seekers might think that applying for protection automatically keeps them safe, but under the new February 2026 rules, those with pending or denied asylum applications are at heightened risk of deportation. Many people assume that staying in the country while waiting for a decision is enough, but federal authorities are now prioritizing cases where applications have been denied or where decisions are still pending and paperwork hasn't been fully processed. This means that even those who have followed all the rules could suddenly be facing removal. Recent trends show that the immigration system is tightening its oversight, aiming to reduce the backlog of asylum cases. For individuals with denied or unresolved applications, this can be shocking news. Years of waiting might not protect you from being flagged for deportation. Authorities can issue removal orders quickly once a case is marked as denied or incomplete, leaving very little time to respond or appeal. So what can asylum seekers do to protect themselves? Stay in close contact with your immigration attorney, keep all notices and documents organized, and respond to any government communications promptly. If your case is still pending, make sure all required evidence and updates are submitted on time. Being proactive, organized, and informed is essential. Your ability to remain in the U.S. may depend on how quickly and accurately you act. Understanding these rules and taking steps now could literally be the difference between safety and deportation. We've invested hours into uncovering these life-changing updates, so if this video helped you even a little, subscribe. It's just one click and supports all our hard work. Comment below with your experiences or questions. Your story could help guide someone else through these complex rules.
Number 10. Individuals who fail to renew green cards or work permits. One of the most overlooked but surprisingly common reasons people face deportation under the February 2026 rules is failing to renew green cards or work permits on time. Many residents assume that once they have legal status, they're automatically safe, but federal authorities are now prioritizing enforcement against individuals whose documents have expired or are nearing expiration. Even a short lapse can put someone directly in the crosshairs of immigration authorities. USCIS and ICE are using automated tracking systems to flag expired documents, sending alerts to federal offices for enforcement. Shockingly, people who have lived and worked in California for years without issue could suddenly receive notices to leave the country if their green card or work permit has lapsed. This includes individuals who are legally employed or have been long-term residents but simply missed a renewal deadline. The consequences are immediate, and ignorance is not considered a defense.
So what can you do to avoid this situation? Regularly check the expiration dates on all your immigration documents and apply for renewals well in advance. Keep copies of all applications and receipts and ensure your address and personal details are up to date with USCIS. Consulting an immigration attorney can also help you navigate any complications or delays in the renewal process. Being proactive, organized, and vigilant can literally be the difference between staying in California legally and facing sudden deportation. Don't wait until it's too late. Your status depends on timely action. We've put countless hours into researching these critical updates, so if this video gave you valuable insights, subscribe. It's just one click and helps support all our hard work. Share your thoughts or experiences in the comments below. Your story could help someone else stay informed and protected. As we've seen, the new rules coming into effect in February 2026 could impact thousands of residents in California, and the risks are broader than most people realize. From prior criminal convictions to expired visas, pending asylum cases, and even missed check-ins, the new enforcement priorities are sweeping, detailed, and stricter than ever before. Even long-term residents, people living in sanctuary cities, or those who thought they were safe, could suddenly find themselves at risk. The reality is clear. Ignorance is no longer an option. These rules are designed to prioritize enforcement against anyone who falls into specific categories, and federal authorities are using more sophisticated tools than ever to identify individuals. What's shocking is that even minor oversights, like failing to renew a green card, working with outdated documents, or missing a single appointment, could trigger immediate action. This makes it more important than ever to stay informed, organized, and proactive. But there is hope. Being aware of these 10 critical factors gives you the power to act before it's too late. Check your documents, understand your legal status, attend all required appointments, and seek professional guidance if needed. Knowledge and preparation aren't just helpful, they could be the difference between staying in California and facing sudden deportation. Remember, staying alert and taking action now can protect you and your loved ones. These rules are not just abstract policies, they affect real people every day. By understanding them, you take control of your future and avoid unnecessary surprises. Your next step is simple but crucial. Stay informed, consult professionals when needed, and never underestimate the power of preparation. Your safety, your residency, and your peace of mind depend on it.